Hey, so good afternoon to everybody. We will have today our second day of international talks on procedural law. In this opportunity, the general topic is procedural law meets competition law. And yesterday we already had the first part of this talks of this conference. With the general title, When Confidentiality Defies Procedural Law, Ideas for Adoption. So yesterday, Professor Thomas Vogt and Professor Lena Hornkoll did some presentations about this topic. And today we are here to discuss some ideas on current developments in private enforcement of EU competition law, nearly 10 years of the damages directive, and more. And for today's seminar, we have as main speaker Professor Lena Hornkoll. And again, I will like to thank for all these activities that you are have been involved in these days, and you are involved also next week in the procedural law department of our Faculty of Law. Lena Hornkoll is a tenure track professor of European law at the University of Vienna, based in Vienna. She studied law in Heidelberg and Uppsala. And she also has a master's degree from the College of Europe in European law and economic analysis in 2019. And then she received her PhD from the University of Heidelberg. Her dissertation, and as we told the other day, is on the protection of confidential information in private enforcement of European competition law. And even if she is a young scholar, she has already some awards concerning her work. And also she has very impressive list of publications already. So she will talk today about these current developments in private enforcement of EU competition law. And then I will present the commentator, Catalina Medel from University of Chile, when Lena finishes her talk. So Lena, thank you once more. And I think you have 30 minutes. Maximum. Okay. Okay, 30 minutes. So this, yes, okay.
Yes, thank you again for having me. You're not sick of me yet. After next week's talk, then I have to go back. Too much procedural law from my. Today I'm presenting a paper I'm writing together with the doctoral candidate from Germany on the, let's say, current trends in private enforcement of competition law. And maybe to put you all up to speed a little bit, basics of what is not in the paper, but just so you know what I'm talking about. So in EU competition law, but all around the world, mostly you have two ways of enforcing competition law, either publicly or privately. So public enforcement by competition authorities with fines and competition decisions. And then, of course, privately through national or through courts with damages actions or injunctions. And what we are focusing on today is only the private enforcement part, the way of how to enforce procedurally competition law in civil courts. And competition law is a nice, let's say, example of discussing this because it is one of the most developed areas of European Union law with the most, let's say, judgments there and also laws that deal with procedural matters. So it can be used as a model for other tools of private law enforcement in EU law. So usually we have competition law developments, and then in another field, the same developments follow, such as data protection law, for example, or financial law. And for damages actions, we stay a little bit with the basics for a minute and with the legal framework that's surrounding these damages actions. They're based on violations of EU law, but they nevertheless constitute a breach of statutory duty in national law. So while the violation is an EU law violation of the anti-competitive provisions, so Article 101, 102, it's the national law that is very important when it comes to the procedural framework and also the substantive rules surrounding competition law enforcement. But the EU is influencing this a lot because as the violation comes from EU law, the European Court of Justice had said very, very early on in the 2000s already in the Courage and Manfredi judgments that the effective enforcement of EU competition law mandates private enforcement. So mandates enforcement in national civil courts through damages actions or injunctions. And because this was just based on jurisprudence and the principle of effectiveness, the Commission started an over 10-year-long drafting process with the EU Damages Directive, which lays down basic procedural rules, some substantive rules as well, for these actions. And then there are also notices and guidelines who are non-binding. So that's a little bit the framework. The most important tool is the Damages Directive. And here you can see on the slide a little bit the overview of what the Damages Directive deals with. So right to full compensation, principle of effectiveness and equivalence in these proceedings. There's a big chapter on disclosure of evidence, the effect of national decisions of competition authorities on private procedures, limitation periods, joint and several liability, then very specific things like the passing on defense. So if something is passed, damage is passed on down the supply chain, what happens? Can indirect purchasers claim? How do you quantify harm in competition disputes? And then also consensual dispute resolution. So the Damages Directive, as you see, it contains not so much substantive competition law at all. It is mostly a tool of procedural law, which gives us the minimum harmonization rules on EU level that member states have to transpose in procedural matters. And in the last year, so the Damages Directive is from 2014, in 2017, it will be transposed into member state law. And we have the first few cases in the last years. And in these cases, you can, let's say, you can find 5 main trends. You find that we are still in a transitional period. You have a lot of judgments focusing on disclosure of evidence because it's a very, very new procedural tool. This year, we had the first decision on judicial estimation of harm. And it was like I would say, a big bang of private enforcement law. We have developments in the area even outside of the Damages Directive when it comes to the jurisdiction rules surrounding private enforcement. And then almost every judgment that is out there deals somehow with the relationship between public and private enforcement and what role private enforcement has. And I will talk you a little bit through these developments, but more in an overview matter. So let's start with the first thing. Why are we still in a transitional phase? So even though the Damages Directive was adopted on 22nd November 2014 and entered into force also in 2014, it only had to be transposed by the 27th of December 2016. But there is a special rule in the Damages Directive, Article 21 and 22, that have a transition or that foresee a transitional period. And they foresee a transitional period for procedural rules of the directive. So we are right now in a transitional period because many of the judgments we talk about today or that reach the highest courts come either from the phase that is entirely predating the Damages Directive or that is from this transitional period where procedural rules can apply retroactively. And there are very, very limited cases where the rules of the Damages Directive already applies. And I can give you 2 examples. These 2 cases from from the beginning of this year and end of last year, they were the first, let's say, cases on the damages directive altogether, and dealing with this transitional period, what constitutes procedural rules and whatnot. And in these judgments, you can see that the determination what is substantive law and procedural law is, of course, interpreted by EU law only. So it does not depend on if a member state says something is procedural or something is substantive. And you see here, for example, in the Volvo judgment, they said limitation periods is a substantive provision, so it cannot apply retroactively. And the presumption of harm, so that something that is presumed in procedures, also is substantive. While then the judicial estimation of damages and also the disclosure rules, they are seen as procedural rules. So we are still in a transitional period, but this year we had a case, the Traficus Manuel Ferrar case, and it will come back, where the court also says, well, we have the directive, we have some rules on substance, some on procedure, but then what you didn't know before is that there are a few rules in the directive that only reaffirm existing case law, and they entirely date back before the directive. So before the directive, we had these Courage and Manfredi judgments, which do not say everything that it is now in the damages directive. But the court says, well, for some of the rules of the damages directive is only reaffirming existing case law. And so all of these rules apply with immediate effect. And they are based on the principle of effectiveness arising directly from the EU treaties. So all of these temporal rules, they are not so important when the damages directive is really reaffirming existing case law. The question is, we don't know what is reaffirming existing case law and what is only new from the directive, because in the end, everything that is in the directive, you could indirectly date back to the principle of effectiveness. So if you look at the transitional phase, we are in a transitional phase where we have national law and the principle of the effectiveness. We have some rules from the damages directive. Sometimes both apply. So sometimes the damages directive is interpreted in light of the principle of effectiveness. And it's super important to understand that this principle of effectiveness is a functional principle of interpretation of EU law, where the Court of Justice always says, well, we interpret EU law as functional as possible, as effectively as possible. And that's still under the directive is a super important principle. So we still have, up until this day, the principle of effectiveness is basically ruling all. If you look at the second trend dates back to something that we have discussed last week already, the disclosure rules of the damages directive. So the next batch of judgments that came out deal exclusively with disclosure, because that was previously not available in the majority of the member states. And therefore, the judgments today, they discuss mainly this because national courts don't know how this works and they don't know how these rules function. We've, as I said, discussed last week a little bit more in depth how this works, but Article 5 to 7 of this damages directive, they give rules on disclosure. You need a request, you need relevant evidence supporting it. The evidence needs to lie in the control of the opposing parties. And then you have also this limit of proportionality, and you have specific rules on evidence that lies in the hands of the competition authorities. And if you look at the first judgments discussing these provisions, and here just like a very high level overview, you can see that so before we had the damages directive, while it was drafted, everybody feared an Americanization of EU procedural law and competition law in general. So very, very broad discovery and fishing expedition, everybody feared that. But if you look at the first judgments that are there, so PACA, for example, from this year, the court says that disclosure is limited and the conditions of the disclosure test, they are very important. So particularly proportionality, very important limit for disclosure. You cannot ask for anything. Fishing expeditions, they cannot happen. You need to have these conditions. And the conditions also of these limits for that stem from Article 6 of the directive, which deals with the documents coming from competition authorities, they have to be taken seriously. So everything that is off limits towards disclosure, so for example, settlement submissions or leniency submissions, they have to be interpreted narrowly, but also precisely. So there are these limits. So you can really see that there's this EU autonomous interpretation based on again, the principle of effectiveness, but at the same time limiting the access to documents. And then again, this Traficus Manuel Ferrer case of this year also stressed the interaction of disclosure rules with other procedural instruments. And it stressed the central role of disclosure in the overall system of damages actions. Because we will talk about this in a minute, Traficus Manuel Ferrer was mainly about judicial estimation. So when can a judge estimate the amount of harm? And there are rules in the damages directive on this, and these rules on judicial estimation, they aim to remedy information asymmetry. So you don't have any information on how to calculate damages, and that's why the judge should estimate the damage. But the rules on disclosure at the same time also function as a tool to remedy the information asymmetry. So the question came up, how do these two tools work together? And in Traficus Manuel Ferrer, the court says, well, before you go for judicial estimation, you have to ask for disclosure. So if you fail to use disclosure rules, you cannot ask the court to estimate. You need to really have a precise judicial quantification, and estimation is only a backup tool. So use disclosure first, which just underlines really the central role of disclosure now in the overall system. So that's the second trend, the focus on disclosure. And then we jump to the quantification and estimation of harm. So this Traficus Manuel Ferrer judgment. And before we go to the judgment, a bit of background on quantification. So the basic principle that we have that still stems from Courage and Manfredi, but also the damages directive, is that there is a right to full compensation. So you need to be fully compensated for all the damages that has occurred, but there should at the same time be no overcompensation. That means, no US-style treble damages, no punitive damages, and so on. You need to have precise quantification and full compensation. And the harm that can arise in the antitrust damages action is mostly overcharge, but also what we call the volume effect of the lost profit down the supply chain. And in practice, quantification of harm is a huge issue. So there's the fight, the meat of the procedures in practice is when it comes to quantification. Usually you need like a lot of experts, economic experts. Every party has their own economic experts. Then there's a court-appointed experts. They all fight about the methods and the way on how to quantify. So quantifying harm is creating huge burdens for effective procedures. And that's why the damages directive has a few, let's say, measures to help. They say that the competition authorities can help with quantification. There's a presumption of the existence of harm. So a cartel causes harm, not the specific amount, but harm has arisen. And then mostly also the possibility of judicial estimation. And the Traficus Manuel Ferrer case was then now this year the first case on judicial estimation. It comes from Spain, and in Spain, judges really heavily have used this provision of judicial estimation because they are in the trucks cartel specifically. There are over 2,000 judgments already. There are cases in all of the regional courts. The courts are really, really overburdened. And that's why they had the judges, instead of going through long procedures and going through disclosure, they went directly for judicial estimation. And they asked the court if this would be possible, if this would be legal even. And here the court said, well, the principle is the precise quantification of harm, and judicial estimation is only the fallback option. So they said they really mitigated this role of judicial estimation only when it's practically impossible or excessively difficult to quantify the harm. So there cannot be any, any other way on how to quantify harm. If this is possible in a precise manner, the precise manner proceeds. And of course, for practice, this creates huge difficulties, as you have to ask for disclosure first. You have to have all of these experts joining and agreeing on methods. The judge cannot simply say, bon, we go with 5%, I'm estimating this. So for practice, this was a pretty, let's say, rough judgment. If you look at another trend that is happening at the moment, we go a little bit into the area of forum shopping. And here I can only be like really, really high level because, otherwise we will talk for another hour here. So there has been recently developments in private enforcement of competition law to use something that we call the single economic entity doctrine, which was previously only applicable in public enforcement of competition law, so by competition authorities. They developed already 20 years ago this single economic entity doctrine that leads to group liability in competition law. So in competition law, you do not look at a legal entity, so a specific corporation. You look at the whole corporate group together, and then the whole corporate group is liable for antitrust fines. So the mother company, the subsidiary, the sister companies, as we call it, they all are liable for the competition law violation. And this recently has been also applied in the Skanska and Zuma judgments from 1.5 years ago, has also been applied for private enforcement. So in private law, where you usually have legal entities and you need to distinguish competition law, in competition proceedings, you say, well, we will not distinguish the whole group. You can file for damages against the whole group. And while it has many, many implications, procedurally, the biggest implication comes when it comes to jurisdiction. Because what happens is that we have jurisdictional rules in Europe. That's the Brussels 1 bis regulation. And there, generally, you have jurisdiction at the head of the company, or this is my watch, this 20 minutes, so I I should stop talking soon, but I will stop talking soon. So you have jurisdiction as the seat of the company that you want to sue. And because everybody or every part of the group can be liable, you can really create jurisdiction in all of the European member states. And this is a problem, and I will just jump over the next slide because it just goes a little bit into detail. This is a problem because the choice of forum in competition law is really, really crucial still. So you have the damages directive with harmonizing rules, but it's only minimum harmonization. So member states can create very favorable rules either for claimants or defendants. And if claimants can choose where they can sue, this can of course be problematic. And if you look, for example, at some examples, there are very different approaches when it comes to quantification. So, for example, the trucks cartel in Spain is handled very differently than in Germany, for example. We have and that we will talk about a little bit next week, we have vastly different rules on collective redress. So, for example, in Portugal, there's an opt-out representative action for competition law. In most of the member states, there's no collective redress whatsoever. So forum shopping is super crucial. And with this new jurisprudence, forum shopping is, I would say, the norm. And to wrap up a little bit with the last trend, which a little bit, puts it back together. So what role has private enforcement overall? So in the system of competition law enforcement. In almost all the judgments that I pointed at now, the court has always stressed this complementing function of public and private enforcement that forms one system of competition law enforcement. So public enforcement via competition authorities is not superior. Private enforcement plays an equally important part and should take over where public enforcement does not have enough resources. So competition authorities are resource constraints. They have lack of personnel, but also other financial means. So they can only deal with, very novel theories of harm or very big competition law violations. But for everything else, private enforcement, so the enforcement in civil courts, should take over. And this role of private enforcement is more and more stressed in these judgments. And while the focus is on compensation on the one hand, private enforcement follows much more also now a public objective. So here, maybe this comes a bit from my dual thinking from German academia, where you always think in okay, what's public law, what's private law, and in other countries that's not such a big issue. But in general, you have now with civil law or civil procedure law, you are enforcing rules that mainly also follow a public aim of prevention, compliance. Some judgments, they even, in Traficus Manuel, for example, they even speak of the deterrent function, the punitive function of private enforcement. So that, I would say, are the current 5 trends. We are in a transitional phase at the moment. A lot of the jurisprudence we have deals with the very, very novel things, so disclosure and judicial estimation. Then national law still plays a huge role. So how member states advance their national law, because forum shopping is very, very easy. And in the end, you still have this issue of, okay, what is public, what is private, and what should private enforcement achieve as a function in the overall enforcement of EU competition law. And with that, I think we can wrap up. And as I said, I couldn't go into depth, but show you the more general trends. All right.
Thank you very much, Lena, for your presentation. Now we will receive comments by Catalina Medel Lucas. Catalina Medel is professor of law of the this faculty of economic law regulation, and she is also expert in institutional design and regulation. And I'm sorry. She was professor, but I think she's still professor of private law, of civil law. And she has a master in the London School of Economics and Political Science, and she is almost finishing her PhD here at the University of Chile. Thank you very much, Catalina, for accepting the invitation that Thomas did to you for commenting this paper by Lena. And you have now 15 minutes if you want to share your comments.
Yeah, no, we talk with Thomas and it will be 10 only.
Okay,
So, yeah.
That's okay.
First of all, I want to thank Thomas for inviting me to read and comment the draft that Lena just presented. And first of all, I didn't knew that I was coming to comment it. Just a week ago, I understood that my role here was as a commentator. I just thought that, very interesting. I'm going to the seminar to talk about the paper. But I found the topic very interesting from the beginning. So it was a pleasure to read. Congratulations. I know it's a draft, but I think the ideas that you presented here that aren't draft, it's a structured draft, but with many things to say. When I was reading it, I thought that more than trends, you could just change the name of the draft. You won't do it, but it's just like challenges of the application of the directive. And these challenges, I think you can just categorize them in 3 topics: application of the directive, proof of damages, and role of the private enforcement. And I will start with the first. It's about the application of the directive. And I think, first of all, for all of us that are here that do not know so much about EU law, what is transposition? And transposition is a deadline, and it's the date where a country has to implement the EU directives, and it's an obligation for the countries. And I think that's very important for your paper, because it states date where the countries should have adapted their national law so they can meet with the damages directive. I understand that by 2018, all member states had implemented the directive. And I think in this first trend of your paper, I think what caught my eye about was the principle of effectiveness. And if you are right, what I understand is that you could go back to case law in every case. So initially, you could have no problem with applying the damages directive. So there would be, in no case, a retroactivity case, if you can always go back to case law. I don't know if you can do that. But I think it's a very interesting question, because if that is the case, you won't have any problem about application, because you will only be applying case law. And what the directive was doing is just to have equal rules in all EU countries. I don't know if I'm right or not, but I think if you approach it that way, perhaps it's less new. But disclosure, I think that's the only thing that doesn't meet my theory of applying case law. And then going to my second topic, that is damages, and why I put disclosure and quantification of damages in just one topic. It's because here in Chile, there was a big discussion last year, between civil law professors about the principles in the damage directive in EU and their application in Chile. So yeah, it's important for us. And the thing is that I think when they were talking about the damage directives, they were talking only about disclosure. But I think, as you said in the paper, it is key for the discussion, the quantification of damages. I mean, as we were talking with Thomas before, like confidentiality or not confidentiality of information, and what do you put in disclosure? And I have many questions for you, where to put the limits, because under a regulation perspective, you should put some limits, just to in order to keep confidential information that you can't just deliver to the market, assuming that not the whole market, like it's in a cartel. But as I was saying, here in Chile, we're just like focused in disclosure, and we were thinking about disclosure as a blank permission or authorization for the claimant to ask for information. And I really, as I said, I really think that it's not the most important thing here in your paper, but the quantification of the damage. And because you have the presumption of harm, you just have to prove the quantification of that harm. The thing is that you said that it was key because all what was involved in proving a harm before a tribunal. But I was thinking in, for example, collective cases. We had like many collective cases here in Chile because we had like some cartels that affected directly consumers, like pharmacies, or we had like a chicken cartel and also a toilet paper cartel that affected directly people. Yeah. And the thing is that how do you quantum that damage under the damage directives? Or what do you think the court will ask in order to prove it? Just to give you an example, in the toilet paper case, each one of us here at the table, we had the right to receive like $9 for the damage caused for the cartel. The thing is, how do you think you will do it? Especially because I understand there is a new directive in this type of cases. And how will the damage directives actually like play with this other directive that came into place? Going back to, I have so many questions. I know I'm not commenting as much, but I think your paper was very, very clear. So I just have questions about your insight about the directive. Do you think that in the case of PACAR, like the limited disclosure can affect like other cases, or it can prevent people from going to the court, to national court, to ask for damages? Because if you, the bright side of the American disclosure is that you know that you can go to a fishing expedition. That's the good thing about the disclosure procedure in the US. But here it will be just like, what do you can give me to make my case of damages? And that could also prevent parties to give all the information they have, just to interpret what the court has said. I think it could be problematic. I understand the problem that and that the court sees, and why in PACAR it asked for proportion in what the parties can ask. But how do you know they will act in other cases? For me, it would be like, if I'm not sure that they have the information, it could be a deterrent to go to court. And in that way, the damages directive also can fail, because the idea, I think that the idea from the damages directive perspective is full compensation, and that you can go to court and ask for that compensation. And I think disclosure actually plays like a fundamental role in that. And about the third topic, I was thinking about how to name it. Change of private informant, tool of private informant, challenges of private enforcement. We don't have like that big difference here in Chile, like in our mind, like structure, like it's private enforcement. This is we have both private enforcement and public enforcement through national agencies. But I think that, of course, the directive change at least a little bit, the way you think about private enforcement and infringement of competition law. So in that sense, you said that a big problem was form shopping. Do you think it's a big problem, or it also protects claimants of damages that in their country cannot get the damages that they need? Or, for example, in countries where it is too expensive to have a competition trial. So you have other options to go to places where it is less expensive, and you can actually demand for those costs. I'm not thinking about like big companies like actually fighting between them about damages. I'm thinking about consumers that are really affected from the cartel perspective. And my last questions, and this is from a regulatory perspective, because I have always thought that every rule that relates to damages, civil, here in competition, it is a sort of sanction, actually. Usually from the defendant perspective, not from the claimant. But for them, it's a sort of sanction too. So do you fear that damages can also here constitute a sort of sanction? And in that way, like national tribunals could use like huge amounts or quantify damages more than the damage actually done in order to sanction the companies that made an infringement to competition law. I'm asking you this because here in Chile, one of the professors here in the university, he claims, and all his analysis is related also to the damages directive, is that we should aim for punitive damages here in Chile in competition law. We don't have punitive damages here in Chile. It's just like the right to full compensation, as you said in the damages directive. But he interpreted that that's a way. And I think it's very, very far away. It's a vision very, very far away from your reality. We're here looking from the damages directive. But I think that perhaps he has a point, because why not? I am a national tribunal. You have a big cartel. This big cartel affected the public. Why not? Why not to put punitive damages in between? Because tribunals, in some sort, they also do public policy. So this will be like a deterrent for other companies. It is in a country, and now you know that that country has really strict, for the people, really strict rules about competition law, and that will be like a reflection of the quantification of the damage.
Thank you very much, Karina, for your comments. I will ask Lena if you want to react, and then we can open
The first thing you mentioned was if we have to go back to case law in every single case. I don't think so necessarily, because there was not for everything a predating case. So for principle of full quantification, for example, there were cases before. The issue is more that even without cases before, can you not, even when it comes to disclosure rules, base them on the principle of effectiveness because for the damages directive, what the court did with every minor thing, and there were cases not relating so much to disclosure, but to access of information in competition authority files. They said, okay, there are no rules on access of information, but in competition law, you need information, you have information asymmetry. So based on the principle of effectiveness, we give you access to information. At the end, we arrive exactly where we have a rule on retroactivity. If you can in theory, interpret everything in light of the principle of effectiveness. Then you mentioned the quantification of damages, and that's actually I have many other papers on this, because this is the biggest issue, and you've seen that correctly. When it comes to collective cases and the consumers, I will talk about a little bit also next week when I talk about this new EU directive, because the collective redress directive does not apply to competition law. So competition law was not included in the scope of application on EU level. There are some member states who, and we call that gold plating. So they transposed the directive and they included provisions. So they included competition law, even though they were not mandated by EU law. And I know, so for example, Germany did that, Netherlands, they did that, in Portugal, they did that, in Italy, they did that, but not across the board. So now when it comes to collective redress, competition law only applies in some member states. There is even collective redress. And so when you have these cases of scattered mass harm, we also have cartels like this. You know, we had a sugar cartel, beer cartel. The problem is always, and we call that the rational apathy of consumers, meaning the individual procedures are too costly and take too long. So for 10 euros, you don't go to court. So you need collective redress. And those member states who have gold-plated the representative action directive, they take different approaches. And I would say, you know, Portugal, Netherlands, they are furthest going because they have opt-out collective redress. Means all the consumers that bought something are automatically part of the class. And then compensation is done more on a lump sum basis.
Okay.
So you have then an amount of damages that is more estimated than a real amount of damages, because consumers in the end, they just want to be compensated to some degree.
Mm-hmm.
They're not so much interested in precise compensation, but they want to automatically be part of the class and then automatically get something, and they don't want to become active at all because that's too burdensome. For 10 euros, you don't want to do anything. Then there are member states, for example, Germany, who've again done a terrible job in doing things like they usually do with these EU directives. My life's goal to change this. We'll see. They have an opt-in mechanism, which doesn't make any sense for consumers. Because if you have 10 euro damages because of toilet paper cartel, you will not go and register even online at a portal from the consumer authority. Why would you do that? It takes you 20 minutes to do this. For 10 euros, nobody is doing it. So the issue here when it comes to consumer compensation is you need effective collective redress. Competition law is not covered. And that is a huge gap in the damages directive. That's the biggest gap that there is. And that's actually the reason the damages directive took 10 years to draft. Because they started to draft right after Courage and Manfredi in like 2002. And then in 2009, they already had a draft that included American-style group action. So opt-out mass actions for consumers. And this draft was leaked to the public. And, you know, it took me a while to get it because they tried to get it back and it's no longer available on the internet, but you can find it. And there you have these group mass actions. But the public was so much against it, or let's say companies were so much against it, they didn't want that. So yeah, but it's the biggest gap that is out there. And then in the end, when it comes to forum shopping, well, the issue is more, again, when we come to consumers, in Europe, we have rules on consumer jurisdiction that usually give the courts closest to the consumer the jurisdiction. Because again, you as a consumer or even small, medium enterprises, you don't go to Portugal for damages actions. If any, you want to do it close to you. And then you might even file an action if there's a bigger amount of harm. So for example, in the trucks cartel, if you are, somebody who transports food to supermarkets, and it's a local company. They've maybe bought 20 trucks, so they have damages of maybe 500,000. You would go to court here, but even for that, you're not flying to Portugal all the time. So the issue with forum shopping is access to justice close to where you live. And that's especially for consumers, then that's a problem. And damages, I mean, if you look at the concept of damages, it's always also a sanction, a form of sanctioning. The issue is if you have a competition authority who already has fined a company, then if you then have treble damages and punitive damages, then you have a second fine. And it's not more so much connected to the compensation function. And at least the jurisprudence we have now, we have full recovery, but not overcompensation. So at least from a European perspective, you cannot have treble damages, especially not if you have a prior competition authority decision. It's probably different when, or you can think different when there's no competition authority action, because then why not should damages take over this role? Which they anyway are. I know.
Yeah, but I have I have a question about the forum shopping, because I was thinking, sugar cartel or over Europe, and you have many consumers. What do you do?
Well, with these, for example, Skanska Summa case law, you could theoretically file a case anywhere. And as long as there is a group of the company situated in that country. And then you can centralize the claim there. But, we don't know how this works then. And we don't know how, consumers from Portugal can participate, or small companies from Portugal can participate, even if only, they want to file an action in Slovenia or God knows where. Also, that's a bit the issue.
So, I'm sorry.
That's okay.
I don't know. A chocolate company chocolate cartel. You have like consumers in Germany and France and Italy and Portugal and Spain. And they all go in their own country. And what do you do with the quantification of damage?
You quantify based on the harm that happens. It's what we call mosaic theory, based on the jurisdiction. So what happens, you can only quantify the harm for France, for the consumers there. Even if you would have overcompensation, then you can have, even if you would quantify too much, there's a redress claim for the other countries.
But it will be then a chance that if you know that some country is overcompensating.
Yes, but the issue is then more that you need to go there to file your claim. And there needs to be, the company that's violating competition law needs to be there. If they're not there, you cannot access it.
No, I know. I'm just thinking in a company that has like many other companies in different countries. And if you're thinking that, I was thinking in Americanization of the EU law, like this fear that you can have like a law. So you can have, you can have attorneys that go to the different consumers. They group them. And then choose the forum
Yeah, exactly. But the problem is more that if you would have more advanced rules, for example, on collective redress across Europe, you don't need to go to Slovenia, Portugal. The issue is about you should be able to argue damages the closest to where you are, because it's also where the evidence is. This is always the idea. Now you have to kind of do forum shopping. That's why all the collective redress actions take place in Portugal. There are 15 cases in Portugal and none in Germany, because that's working more or less. But I mean, up until like one or 2 years ago, there has been a study from a Portuguese colleague. There has been, for consumers in the whole Europe, no compensation. There was never a successful compensation for consumers in the whole of Europe up until very recently in Portugal. So it has not been working at all up until Portugal really, they have a rule in their constitution that allows consumers to do that, and they have changed all their system. But yeah, it would be more harder to get to Portugal, as you know, as a German consumer. When you have a 10 euro damage, you don't even go to the German court, let alone there. And there is if you have measures through things, but if they're not there, then you don't have procedural tools to do that.
Thank you.
So we have also a question from the public. I will read it to you. And then I'll ask if Thomas, and your name was?
Camila.
Camila wants to. And also if the public want to speak, I think we can give them the opportunity to speak. I'm not sure. Okay, I'll read it straightforward. This is the question. Regarding judicial estimation of harm, Professor Hornkohl mentioned that first is required to seek disclosure, and then, if disclosure is not possible, the judge can estimate damages. I would like to know how parties can discuss or review that estimation if they already don't have all or a relevant amount of information. Question from the public. I don't know if you did it, but thank you very much.
Yeah, so I mean, that's a little bit the background, that's the jurisprudence in the Traficus Manuel Ferrer case. It has been, that the court said, in general, you need to go for disclosure before asking for estimation, because based on what is disclosed, you can fully understand the precise harm, the precise amount of harm. And only if disclosure is not possible, or if it's too burdensome, or you have gone for disclosure, but even after disclosure, you're not sure how high the harm is, then you have to estimate. And of course, any estimation is non-comprehensible. It has to be based, estimation in the sense of the directive doesn't mean, we just do anything, but it is a lessening of the standard of proof and the lessening of the standard and burden of proof. So it's mitigating what parties need to bring. If there is really no evidence whatsoever, the court is not allowed to estimate. But what they can do is they can use the available evidence. So if they have something, they can use this as an estimation ground, so to speak, without the need to be fully precise. And then that's then the basis. Parties can also understand the estimation. So it's not completely detached from any evidence, any logic. It is just you use what you have, and the court is under no obligation to look for, the parties are under no obligation to bring everything and look for everything. But as Traficus Manuel Ferrer said, that's only last resort. You first need to go to the precise as possible, and only if that's not possible.
Thank you very much. I don't know if Thomas has further questions or even Catalina. No?
Yes,
I ask many.
Okay.
about the same thing that so is there no way damages can be rejected?
Yes.
So if you don't get disclosure, you get an estimation. So
but that's
win-win, or how do I have to think about it?
No, so that's what I mean with there needs to be some kind of estimation ground. It needs to be based on something, some evidence, some material. So you can reject, of course, or you can say that there has been no harm whatsoever, or there has been not sufficient proof if there's really nothing, and if there's really very, very limited. Of course, it's the boundaries are not set in stone, for some things you need more, for some things you need less. If that's a really easy price cartel and the amount of cartelists is limited, and it's been not many supply levels, then it might be much easier to estimate something compared to when it's a really complex cartel. There has been many levels, and if then you don't have enough evidence. And disclosure is not helpful because, maybe the cartel was 10 years ago and there's no more documents. And then the judge cannot say, okay, you arrive at 5%. That's not possible at all.
Are there negligence consideration? Like if the litigants
Yes, exactly. The court said that.
were negligent in gathering information and
Exactly.
don't care,
Like the court,
you can estimate it. There's enough stuff to estimate. I don't know.
No, that's not what they said, but the court said something. And I quote here the court: if the practical impossibility of asserting the harm is the result of an inaction of the parties of the claimant, is not for the national court to take the place of the latter or to remedy its shortcomings. It's a very, upfront message from the court saying, well, if the parties are negligent, the court cannot take over. The court can only take over if the parties have done their best and if there is something, and if they've brought some evidence, and then there can be estimation. But if the parties are too lazy or if there is simply no evidence, you cannot have a quantification. I'm fighting the biggest battle with other academics in Europe because many academics want to have, or mostly practitioners, but also some academics want to have presumption of a precise amount of harm. So what we have in the directive at the moment is we have a presumption that harm has occurred, a rebuttable presumption. But the amount of harm, as also you said rightly, is not covered by the directive. And many practitioners say, well, but it would be so easy to have damages actions if we would just have a by law presumption of 5% of overcharge, for example. But there is absolutely no empirical evidence that cartels always cause 5%. Some cartels cause 60%, some cause nothing. So by law presumption of the amount of harm, not all, there are really two parts of like the academia and practice in Europe. The half of them is saying we need that to make it more effective. But for me, there's not enough evidence there.
That would be a sanction.
Yeah, exactly. I have the same thought because there are different reasons for establishing a presumption. Some are established on the basis of the typical harm in similar situations.
Mm-hmm.
And there you say it would be nonsense if that's a justification.
But that's the justification.
Okay, then it's
that's the justification for the presumption of harm.
But you could also say for regulating purposes, it creates some certainty and also certainty in litigation. You know what the stakes are. So it would have some benefits in regulating the conduct of the involved. It wouldn't be that nonsensical and that as a deterrent. Like if you put a very high presumption of damage.
The issue is always with damages in Europe, we don't need it because we have public enforcement.
Yeah.
We don't need the deterrent factor as much because for deterrence, we have the fines. If that is somehow not working anymore, because, we see competition authorities, they don't enforce price cartels anymore because they think, it's too easy. We rather look in the Google, Amazon, Facebooks of this world, only do very sophisticated things. Then you can think about it. But I think it needs to be based much more on, empirical knowledge of how competition authorities use or how they fine, and not now, okay, we want to have it just easier and create a really system where nothing is based on,
real
things anymore. You never have in the outcome of court cases are never the reality, but still, if you detach it completely from what's happening.
But there seems to be a problem that estimation had multiple functions. At the functions to compensate some disclosure issues, none that were not due to the negligence of the party, innocent disclosure issues. And on the other hand, it seems to be a possibility. It always reminds me to a German discussion. There's a German provision in the ZPO about the the power of estimation.
Yeah.
Where's the discussion? What's the function?
It's basically where the drafting comes from the
okay.
So they saw 287 of the German Civil Procedure Code, which gives this estimation based on, based on available evidence.
So the factual basis that has to be proven.
Exactly. You have to have a factual basis that needs to be proven, and on that factual basis, the court can estimate. And that's a little bit where the drafting is coming from, also on EU level. So it is never supposed to be this we just arrive at some.
But it has the ambiguity,
Yes.
this norm, because you could always say when the facts are complex and need projections, so to say, then you can kind of calculate some, you can use, I always thought about the norm also as a possibility to use some established methods to calculate the damages without having traditionally have the traditional certainty of the German standard of evidence. So you can use these methods and it's okay also.
Yeah.
That's the other function, avoiding that a high standard of proof have as a result that in some activities the proving of the damage is destined to fail. And so no, this can be the case or typical where you cannot traditionally prove the damages and you have to make some calculations, some projections that are not based on certainty in the fact, but are well-established methods. So that's the other function, but it seems to me that this ambiguity reproduces now on this very, very interesting and just another.
There's a further question. Can you read it forward or not?
I can also read it here.
Sorry, not.
Daniela Vasquez has a question.
Okay.
Almost not.
Maybe you can read it.
The question is regarding disclosure. The problem with the limited disclosure, does this happen generally or only in preliminary procedures? Because I mentioned that the ruling in PACA prevented fishing expeditions, so I was wondering if it was more strict during that stage. So the wording of the directive is a little bit unclear whether or not it covers pre-trial disclosure or also only in-trial disclosure. Because and here we have a typical problem in Europe. We have so many different languages, and then the language versions differ. So the English and the German, they say in proceedings for competition law. And then the question is, does in proceedings mean only for the damages, or does in proceedings mean pre-trial? In the case at PACA, it was a pre-trial case. But that depends on the national system, how they transposed it. So, for example, in Germany, they have transposed pre-trial disclosure, while other countries only have in-trial disclosure. So the limits of disclosure apply across the board, whether or not it's pre-trial or whether it's in-trial, because it's in the text of the directive. It gives conditions for disclosure. So you need to fulfill certain conditions. It needs to be reason, needs to be necessary, relevant, proportionate, which at the same time serve as a limit for disclosure. But you can see in PACA specifically that it does not go as far as preventing ex novo evidence. So that was PACA, and in the essence was the question, is the defendant obliged to create new evidence, or does the evidence need to be pre-existing? Does it already had to be there? And with the ex novo, I think what they wanted is, instead of having individual documents, they want a list with the information on it. And the court said, well, if it's more effective to have this list rather than to have 10,000 other documents, ex novo disclosure is not an issue. So you see here, while the court in their operative past talked a lot about disclosures limited, there are these conditions, proportionality is very important, but that doesn't mean that they cannot end up at a very extensive reading of these provisions. Yeah.
And just thank you very much, Daniela, for the question. And I just a last question about the forum shopping
Mhm.
problem.
It's like a really interesting topic for us.
Yes,
Yeah.
because you describe the problem, and on the one hand, it's a very predictable problem. Like the point of everything is that European citizens are on the same footing, so it doesn't matter where they can claim when they suffer. So that's the whole point. So it's a very and to give broad access to be able to claim, file the claim wherever they want, and also for the effectiveness of of this regulations. So. But the cost, it seems to me that the costs is a function of the whole sector. If you have like some forum where people always go to, and other where less people go, and maybe in different topics or different areas, different people go to different countries to have the claim looked at. So is there a solution to this, or is this avoidable, just a cost of this idea of access? And it's like it seems to be a logical byproduct of it that is difficult to be resolved. Like the directives are like the general guidelines for uniformity, if you want, but it's unavoidable that the regulation and the reality, the law in action is different, and so is there do you see this as something we have to accept, or are there solutions to this?
The issue that I have is not so much with the forum shopping itself, because if you want to go to another forum because it's easier for you, and if this is manageable, okay, do it. It will not happen in practice for the reasons I said earlier, because especially small and medium enterprises, consumers, they don't go to another country to file a damages actions necessarily. The issue is, for me, it's more that at the moment it's nice to see, okay, in Portugal we have a bit of a trial and error. How does kind of collective redress work? So we see a little bit. This works well there, so we maybe adopt it for the EU. It's just until we have then more harmonized rules on EU level, you have very different level of protection. So what we do not want in the European Union, we always want to have an internal market, we want to have integration, we want to have access to justice for all European consumers and citizens. But if you then don't have enough harmonization, it really again depends on where you're situated. And that's more the problem I have with forum shopping. It's just that we have not enough harmonization in matters that are very crucial. So I think that's the bigger issue.
How can you enhance harmonization if you already have the directive that seeks harmonization?
But only minimum harmonization, and in most areas, minimum harmonization. But if you look at, for example, this draft that was leaked in 2009, it mandated group actions for the whole Europe. Then it would not only be Portugal who had an opt-out collective action. If you would put in if we now have, and the directive is now nearly 10 years old next year, and they want to, after 10, 15 years, they always look in, okay, are the rules working? Are they not working? And then they modernize them. And to have a provision maybe in a new directive saying, we want opt-out consumer collective actions, and member states have to do that. That's a minimum harmonization level, but that's at least a level where you can work with. And for many things, you could have what I don't want, but you could have a precise prevention of harm in a directive. So the idea is more modernize this directive, so you don't have individual member states who are forerunners, and then the rest of Europe is just left behind. Oh, I'm not in Netherlands. Yeah. So
the crucial issues that generates like this different approach to collective action that generates it. It's like, it makes sense. Thank you.
I would like to question where they are precise and are about the functional of the European Union law, which is foreign for me. Those 6 members states of the European Union that has criminal sanctions for damage, and if there is 6, it can applicate national law over the European law, or how does works the harmonization between European law and national law of their member states? And I had other question. If in the European law, is there some kind of mitigating factors for companies that, I don't know, being persecuted by cartels or something? They disclosure their information to the court and helps to clarify. Is there some mitigants or there has no relevance?
Okay, so I mean, of course, I didn't explain all this harmonization because that's introduction to EU law lecture that we can also do. I'm teaching that at the moment in Vienna, so we can also have a whole discussion on this. But usually how it works is we have in EU law something called the principle of primacy, meaning if you have an EU provision that has direct effect, or not even those that have direct effect, but if you have an EU provision and there's a national provision that is contradictory, the EU provision proceeds over national law. So the issue with directives, it's always that they have to be transposed by the member states. So while directives have primacy, then if a national law is violating that, it has to be interpreted in conformity with the directive. So then in the end, EU law always has primacy over member state law. That's why I always, wrongly call it a quasi-federal state, because it's not a state, but it has the system. And this quality is what we call supranational law. So it is not national, it's not international, it's in the middle bit, a little bit in between, but like EU law has this by virtue of, itself, because member states transpose powers to the European Union. And in these areas where they transpose the powers, European Union supersedes member state law. So that's a bit the idea. And then mitigating factor, yes, we have leniency programs and settlement programs and commitment programs. So leniency is what you described a little bit. I've done a cartel, I want out of this, and so I'm going to the authority and tell them, okay, we have a cartel, so then you don't get a fine. That's how it goes. If there's already an investigation ongoing, you can have settlements with the authority, meaning you can just simply say, okay, here's more evidence, but please give us less fine. And the commitments work very similar.
Okay. Thank you.
All right.
So if there's no further questions, I think it has been a very interesting seminar for all of us. Thank you once again, Lena, for this talk. And thank you also, Catalina, for being in charge of the main comments here. And thank you, everybody, for participating. And with this, we have put an end to this second round of seminars, procedural law meets competition law. And we invite you to the last talk.
More collective redress.
That is going to be 19th at
Tuesday
at 2:30 in Auditorio Alessandri. So there we have the seminar, Collective Consumer Redress after the EU Representative Actions Directive, the way forward. So everybody of us is very welcome to this last seminar. So thank you very much and have a nice day. Thank you.